Now in session.
Gentlemen, we appreciate you participating in this oral argument via Zoom. Obviously, it's not the way we'd like to be doing things, but it's the best way to do things under the circumstances. We will be utilizing the same procedures and protocols as if all of us were sitting in the courtroom today together, which essentially means each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time, you'll receive your rebuttal time if you've done that with Mr. Hibner before we started today. Before we get started, I want to take an opportunity to introduce your panel for this morning. Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we call the case?
I know, Your Honor.
All right, you may call the case.
Re Carlee A.
And we will hear from the appellant.
Good morning, Your Honors. I've requested 5 minutes of rebuttal time on this. Luke Sanderson here for the appellants. We're here today on an appeal from Shelby County Circuit Court in a case regarding a surrender, a revocation of that surrender, and a subsequent adoption of a child. Not to belabor the facts too much, but in this case, my clients are the grandparents of this child, and they had a custody order from juvenile court pertaining to this child, giving them sole exclusive custody of this child. They sought out Bethany Christian Services as an adoption placement service to go in and find a match for them for an adoption of this child. The Avilas were identified in this case as the prospective adoptive parents of this child. During the course of this, prior to the filings of any of these pleadings, several representations were made by the Avilas that my clients relied upon to go forward and have them as the adoptive parents of this child. Namely, that my clients would be able to stay in the life of this child and be the grandparents of this child, typical of any grandparent relationship with a child. The reason we're here today is because the Avilas did not live up to those promises. But for those promises made by the Avilas, my clients would not have surrendered this child to the Avilas. They would have picked someone else who was going to allow them to be a grandparent to this child and be in this child's life. The issues that we're here on today, cited by the appellees, that we did not file a proper Rule 59 motion to alter or amend that judgment. We strongly disagree with this matter. The crux of our motion to alter or amend in this case was based on the order entered in the trial court dismissing the claims of this case and dismissing this case. A careful reading of the trial court's order in this case would show that the claim of IED, which an intentional infliction of emotional distress, which we believe to be one of our strongest claims, was frankly left out of this order. It was not discussed. There was a lengthy discussion in the order of every other issue that was being dismissed in this case, except for IED. Now, we were asking for reconsideration of that ruling on this and wanted to know, should this claim have been dismissed? Was this something that the court did in error? Because they certainly did not address it in their order on this case. But we believe that was timely. There was one motion filed within the 30 days. We filed an amended motion actually before a response was filed, which that is the controlling pleading in this cause because the response was not filed. I don't believe that's being contested by the appellate, but I wanted to make sure that was straight. Anyway, the crux of this case and the crux of this case at trial, notwithstanding the claims that we have for the tortious claims, which we believe should not have been dismissed because they are all questions of fact. We believe they were properly alleged. Every element of these cases, every element of IED was alleged. Extreme and outrageous conduct was alleged. That conduct specifically are these people who have fraudulently made these representations that this child is be in the lives of these grandparents, which that's not holding up. I can't think of anything more extreme and outrageous than to deprive somebody any kind of contact with the child that they've raised since birth. Secondly, the fraudulent inducement claim. The fraudulent inducement claim, our argument has been mischaracterized throughout this entire proceeding. It's been mischaracterized because the appellees are stating that we're trying to enforce a certain contract. That's not what we're trying to do. We understand that post-adoption contracts are not enforceable. What is enforceable is the surrender. That contract that was entered into was only entered into by fraudulent inducement. As I stated earlier, my clients would have never entered into that contract if the fraudulent statements would not have been made by Bethany Christian Services and the Avalas. So we believe that claim survives this as well, and that's something we sought to alter and amend in that form of pleading as well. But the interesting point of this case, the crux of this case, as I mentioned, is we're claiming for the application of the discovery rule to be applied to surrender cases, to revocation cases, and so forth. The statute states that,
Mr. Sanderson, your clients did your clients have guardianship of this child, or did they have custody of this child?
They had a juvenile custody order. I believe it's in the file. We certainly submitted it with the record here, but they had a custody order in juvenile court, I believe. I don't want to make a misrepresentation to the court, but they had rights to the child that were not being contested, and that would have gone on ad infinitum in juvenile court.
And so, were those something that that fall under the surrender statute?
Yes, Your Honor. Since they did have the rights to care for this child, it is something that they could surrender. They certainly had a right at some point. So if they had a right at some point and they did give it up, we're contending that that's a right that they should be able to get back in this case.
Thank you.
Sure. Anyway, as I was saying, the crux of this case is the application of the discovery rule. The statute states that when fraud's present, it may be filed within 30 days of this thing. Well, our point is pretty simple. Any well-perpetrated fraud my clients would have no opportunity to file a suit if they hadn't discovered it. So a fraud that we contend is the MO of Bethany and the Avalas in this case, to stall out as long as they could past the 30 days, then drop the hammer on my clients and say that they can't visit the child. At that point is when we're saying that's when the statute of limitations, the 30 days, should start ticking. Now, they didn't realize that they weren't going to be able to be in this child's life till October after they executed the surrender in May. Within the 30 days of that, certainly we filed a suit to revoke that surrender.
So what's the fraud here?
What's that, Your Honor?
What's the fraud?
The fraud is the misrepresentations that the child was going to be able to visit with my clients. That hasn't happened. They sent communications.
Stay with me here.
Sure.
Who made that fraudulent statement?
The Avalas made that fraudulent statement, Your Honor.
Okay. And let's see. How do you know that it was fraudulent when it was made?
Well, we've certainly alleged that today. We haven't been able to conduct any discovery in this case, but we have alleged that they had no intention to keep this promise on this. We are aware of several of these instances involving Bethany Christian Services across the country where this same problem has arisen. I think the evidence of just the entire cutoff of the communication shows that they never intended on living up to their end of the bargain here. We were granted in Chancery Court opportunity to take discovery and to take depositions. While that case was pending in Chancery Court, unbeknownst to us, a case for adoption this is the revocation case. While that was pending in Chancery Court, and what we believe to be forum shopping here, a case was filed in circuit court to circumvent that and to toll that because they didn't get the result that they wanted on these depositions. So we were never allowed to take those. And we believe this to be a question of fact and not ripe for a motion to dismiss, because we believe we can show that through discovery, and we certainly allege that. Anyway, we did fit within that 30 days of the discovery of the fraud. And as we've stated in our brief, the discovery rule is applied in pretty much every facet of cases involving fraud. In medical malpractice cases, Chambers v. Dillow; in tort law, Foster v. Harris; and in legal malpractice, Americount Club versus Hill, and we've cited to those. there's no reason why it should not be applied in this case. And we know this is a case of first impression on this. We've combed the law to find anything on this, but it will be impossible for my clients to file anything within that 30 days, because that's when the fraud was occurring. They were certainly living up to their ends of the promises during that period, but shortly thereafter, that's when it stopped. That's, when Bethany thought, okay, or the Avalos thought, okay, we've passed our 30-day limit. Let's not let these people see this child anymore. That's when it was discovered, and that's when the statute of limitations should start ticking in this case. We think we've alleged all the elements, like I said, of fraud appropriate in this case. We've walked through the elements of fraudulent inducement in here. It's certainly in our complaint. There was an intentional misrepresentation of a material fact by the Avalos and Bethany that the Smiths will be able to remain a part of Carlee's life. There was knowledge that the representation was false, or made knowingly or recklessly without belief or regard for its truth. They never planned on upholding the assurances. We've certainly alleged that. Their actions alone have evidenced that they didn't plan on holding this up. If they wanted to, then they would have this child in their life now, or allow my clients to see this child now. That hasn't happened. And a reasonable reliance on this, my clients relied on this, and they would not have entered into this contract with them or entered into this surrender if they had not said that. And we think that's reasonable to rely on that, because they were dealing with a big company, Bethany, and they wouldn't have thought any otherwise. So I'll yield for Mr. Carter.
We'll hear from the appellee.
Thank you, Your Honor. If it pleases the court, I am Richard Carter with Martin Tate Morrow in Marston here in Memphis, and I represent the appellee, or the appellee Bethany Christian Services of West Tennessee, Inc. on this appeal. I will address the procedural issue of the notice of the failed notice of appeal, as well as the dismissal of the Smith's tort claims. My co-counsel, Mr. Weaver, will address the adoption and surrender issues, and we would like to reserve 4 minutes for him to do so. The first issue, we believe, should be the only one the court needs to address, because the Smith's failure to give timely notice of appeal would deprive this court of jurisdiction to decide the remaining issue. Here, the Smiths failed to timely file a notice of appeal or a proper Rule 59 motion that might pull the running of the time required to file a notice of appeal. And for that reason, the court would like jurisdiction to address the other issues. Judge Wagner issued her order dismissing this case in its entirety on May 27, 2020. The Smiths first filed their notice of appeal on September 17, 2020, nearly 4 months after that. Therefore, in order to have met the 30-day requirement, we must look to see if the Smiths timely filed a Rule 59 motion. They did not. On June the 19th, 2020, the Smiths filed a motion labeled Rule 59 Motion to Alter or Amend the Order Granting Motion for Summary Judgment and Motion to Dismiss. This court in Getz versus Oughton carefully reviewed the analysis that has to be applied in cases like this. Getz teaches that, one, an appellate court cannot simply rely on a motion's title. Getz also teaches that courts must parse through the body of the motion to determine whether it requests the sort of relief available through one of the 4 motions specified in the procedural rules. The Smith's motion simply does not qualify. The crux of that June 19th motion is stated in paragraph 2 of that motion. There it says that the order granting motion for summary judgment and motion to dismiss were silent as to whether or not the claim for monetary damages has been dismissed. Paragraph 3 goes on there simply to say that they're seeking clarification of whether the court dismissed or didn't dismiss. The problem is that the trial judge clearly and unequivocally stated her ruling on dismissal of those. She said, for all of these reasons, the Smiths have failed to state a claim upon which relief can be granted for any claims of money damages, and therefore these claims, causes of action, must be dismissed. So the whole basis for their motion is that it was missing from the order is wrong. It was in the order, and they only ask the court to clarify. In Getz, this court also ruled that motions that are not proper Rule 59 motions have no effect on the 30-day filing period. In Getz, the court enumerated the bases for that, the change in law, a new discovery of new evidence, a clear error on the part of the court. None of that was alleged or argued at all in that June the 19th motion. They simply sought clarification. The trial court looked at it, applied the Getz standard and said it is not a Rule 59 motion, and that is a proper ruling and it should stand. And when that motion, if that motion is not a Rule 59 motion, and it is not, then on June the 26th, the time to file a notice of appeal ran. After that, the horse is out of the barn and you can't get it back. Okay? They try to rely upon the July 6th, 2020 motion, where they tried to amend their defective motion, but the horse is already out of the barn. The time has already run. They argue relation back under Rule 15 of the Rules of Civil Procedure. The fallacy there is that a motion is not a pleading. The relation back doctrine applies to pleadings. So they fail on that ground. Now, if the court chooses to go further and look at the tort claims, the trial court also properly dismissed those claims. The Smiths made claims for intentional and negligent infliction of emotional distress and fraudulent inducement into a contract for the surrender of a child. That's what they asked for. Yes, ma'am.
Mr. Carter, let me ask you a question there. The claims that you're discussing here and the tort claims, were those claims properly pending in the circuit court matter or in the chancery court matter?
They were properly pending in the circuit court matter at the time. All of the matters had been consolidated there.
Was an order of consolidation entered as to that?
I believe an order was entered. Actually, I don't know that an order of consolidation was entered, but the court had taken jurisdiction over that cause of action.
Well, I understand that the court acquired jurisdiction over that, but I guess what I'm asking you here is it your position that the court was ruling on everything at one time?
It
As
is.
a result of that.
That is our position, Your Honor. And we believe that was a proper action on the part of the court.
Thank you.
Your Honor, with regard to the tort claims, they did not argue negligent infliction of emotional distress, argue against the dismissal of that at the trial court or here. So that action is out. The other two are intentional infliction of emotional distress and the fraudulent inducement claim. Both of those are based on an allegation that in paragraph 4 of their complaint, they set it out. Mr. and Ms. Smith were to be able to contact and visit Carlee anytime within reason, and Mr. and Ms. Smith were to remain in Carlee's life as grandparent figures throughout her childhood. They reiterate that at paragraphs 6, 7, 8, 9, and 9 of their complaint and sum up their alleged injuries at paragraph 18, where they say they experienced significant psychological and emotional distress by being kept from the minor child. That's the basis for their claim. The problem that the trial court seized upon is that Tennessee Code Annotated 36-1-121F, as it existed at the time the motion was decided, clearly and unequivocally, and in 3 different instances says that that you cannot, the court cannot order such, parties cannot agree to such a limitation, and that the court cannot enforce that. It says indeed, it says that placing any conditions on an adoption shall be void and of no effect whatsoever. It says later, at the end of that section, that permission or agreement to permit visitation or contact shall not in any manner whatsoever establish any enforceable rights in the parent or guardian, the siblings or other related persons. Therefore, the whole factual premise of their fraud and their intentional infliction of emotional distress argument is a legal nullity. It cannot be given any consideration or cannot be enforced in any way whatsoever. And they should not be able to try to circumvent the clear and unequivocal legislative enactment of the legislature by giving it a different label. And here we believe that it also, they can't reasonably rely upon such representations, that we would contest the representations were made at all, but we certainly do not believe they could reasonably rely upon that which the legislature has said is of no effect whatsoever. And therefore, we believe that the trial court properly dismissed all of those claims. Thank you. At this time, if I may, I'd like to turn the rest of my time over to my co-counsel, Mr. Weaver, unless the court has a question. Thank you.
See none. Mr. Weaver?
Good morning, Your Honor.
Good morning.
Your Honor, if I can go back and
Mr. Weaver, you need to introduce yourself.
I'm sorry. It's Kevin Weaver at the Memphis Bar. I do also co-counsel and representing Bethany Christian Services in these proceedings.
All right, sir, you may proceed.
Thank you, Your Honor. Your Honor, I would like to go back and address one of the questions that Judge McGee had about the surrender early on in Mr. Standard's argument. She was asking about if the Smiths, Mr. and Ms. Smith, had any rights to be able to surrender. And I think the accurate answer to that is no, they did not. They did not have guardianship of this child. They simply had custody of this child. Under the surrender statute, it states that if you have a surrender, which was done by their son, he is the legal father of the child because he did an acknowledgement. It's not in the record, but later DNA testing was done to show he was not the father. So he's not the biological father. He surrendered rights. Under the statute, it says if someone else holds custody of the child when a parent surrenders rights, they can waive that custody. That's exactly what happened in this case. The surrender included an affidavit where the Mr. and Ms. Smith, the presumed legal grandparents, waived their custody of the child, so that any revocation of a surrender would have had to been done, could only been done by the son, which he ultimately did on their third amended petition. So just clarification on that. Furthermore, the whole statute, I think you have to look at the whole adoption statute to help understand why 36-112 is drafted like it is. You go back and look at the purpose of the adoption statute. It's very clear in the very 36-1-101 that gives the purpose of the statute. It emphasizes two things: permanency for a child and things done in an expeditious manner. I know the court knows that even under the appeal part of this, everything is expedited. So when you take that and you put it into 36-1-112, it talks about there's two ways to revoke the surrender. You can do it within 3 days for any reason, no reason at all. You can do it within 30 days if you are able to, if you file within 30 days of the surrender, a petition alleging fraud, intentional misrepresentation, or duress. But that 30 days is I mean, that's it. It's after 30 days. This was filed some 5 months afterwards. Now, there is a provision under 36-1-118 that says if circumstances arise between the time of a surrender and the time of the adoption, that there's reason that the child shouldn't be adopted for best interest reasons, those circumstances can be brought before the court. Those circumstances, though, they're not talking about the grounds under 36-1-112. Circumstances such as, I've had this happen on occasion, but before the adoption's finalized, the adoptive couple files for divorce. It sounds crazy that would happen, but it happens. And so those circumstances are such that are not covered by 36-1-112. So fraud doesn't fall underneath there. Intentional misrepresentation doesn't fall in there. It doesn't do anything to expand those provisions. And the reason is,
question, Mr. Weaver, what about Rule 60? How does it fit within this framework?
Well, Your Honor, Rule 60 typically, what I have seen with it is in terms of if there's some party that wasn't given notice, something that wasn't done procedurally right in the process.
Doesn't Rule 60 have a fraud provision as well?
Yes, Your Honor, it does. But I think when it's looked at in the context of the adoption statute, we know the adoption statute's to be strictly construed, and it says what it says. I don't think it, unless there's some jurisdictional issue, I think that is that's not been addressed. I don't think Rule 60 would override what the statute allows or states the timeframes in this particular case.
Okay. All right. Thank you, sir. All right. We will hear the appellant and rebuttal. You're muted, Mr. Sanderson.
How about that?
There you go.
Thank you, Judge. Going back to what Mr. Carter was saying about the timeliness of our motion to alter and amend and actually the substance of our motion. The case he cited, Oughton, states additionally a Rule 59.04 motion can provide relief from a judgment due to mistake, inadvertence, surprise, or excusable neglect. Now, a reading of that order of the dismissal on this, it could clearly be inferred that there was a mistake or excusable neglect involved in the judge's ruling on this. There's a careful...
Let me stop you there just a minute, Mr.
Sure.
Sanderson. The trial judge specifically said, wasn't no mistake. I said what I said. You weren't entitled to relief. It's a specific finding by the trial judge that her order dealt with every claim, every issue that was raised. So what do we do with that as the appellate court?
Sure. Well, just because our motion was denied does not stop the tolling of this.
But what I'm saying, though, is you're saying the reason I filed this Rule 59 motion was because there was some ambiguity, there was some uncertainty about the order. The trial court said there is no uncertainty about the order. The order specifically dealt with this. It said what it said about dismissing all claims. We've got a finding from the trial court. So I assume you're saying the trial court made an erroneous finding on that. Is that correct?
Yes, Your Honor, that's what we're saying there. We are saying that. And
what's your basis for that?
The basis is that we've pled all the elements for IED in our complaint. I mean, it's a question of fact at this point. But going back to this, and I think it does relate.
Is it a question of fact or is it a question of law?
Well, I believe she erroneously made it a question of law, but there is actually a question of fact based on our pleadings.
And what is the question of fact?
whether or not this was extreme and outrageous conduct here to constitute IED.
Okay.
Whether or not the conduct arises to IED. But just because we lost that motion, that does not mean that our statute is not told. If you lose a motion to alter and amend, you can still file a notice of appeal within 30 days of that. So we filed it.
If it's a true motion to alter or amend.
Correct. We believe it to be a true motion to alter and amend based on that. So we are appealing her decision on that, stating that it wasn't as well. And we want that to be clear. But I mean, looking through this, I think it could be inferred from the reading of her, from her original order, that we were alleging it to be a mistake, inadvertent, surprise, or excusable neglect in here. That's why the essence of
okay.
our
Let's work through that mistake.
Sure.
What's the mistake? Inadvertence or excusable neglect?
The mistake is that we believed that she did not mean to dismiss the IED when we filed that motion to alter and amend, because every other element in here, every other tort that was alleged was carefully walked through. It was everything was said about the elements and everything. There's a brief mention about some tort claim, a blanket mention of this, but every other claim in here was broken down and cited to. And we couldn't fathom why our IED claim could not still prevail on this motion, or still prevail in this claim, because we believe that we alleged all the elements. If we've alleged all the elements, then it is a question of fact. So we believe the trial court erred in dismissing that. That's my point there. Real quick before my time runs out, Mr. Carter is still attempting to mischaracterize the contract in which we're discussing here. We're talking about the surrender here. We're not talking about a post-adoption contract. The language in there that says no effect whatsoever, that language is specifically about the post-adoption contract. That doesn't mean fraud that's represented to enter into the revocation of the surrender by my clients, including the legal father of the child. It can't mean that, because there is a provision for fraud in the revocation doctrine. So what else would have been relied upon other than statements? So those statements, while they may not be encompassed for purposes of the post-adoption contract, that does not mean that those statements cannot be used for our tort claims and for our revocation claim there. But again, I believe that we are on solid ground for our motion to alter and amend. We allege that there was a excusable neglect or mistake in there by dismissing that claim for IED in there. And she said it wasn't, and that's fine. But we believe our motion to be proper, because that's what we were alleging, that was mistakenly dismissed at the trial court level.
All right, gentlemen, thank you for your argument. We will endeavor to get you an opinion on this matter at the earliest possible time. We appreciate you participating with us today via Zoom. Mr. Hebner, anything we need to take up before we recess to the call to the next case? All right, you may recess the case.
This item is now recessed until 1 p.m.
All right, thank you, gentlemen.
Thank you.
Your Honor.